Good morning, everyone. My name's Matt Dana. I'm the managing general partner of Dana Whiting Law, and here I'm with my partner today, Todd Smith. Good morning, Todd.
Morning, Matt. How are you today?
Good to see you. I got my black jacket on today.
Oh, good.
Very conservative look, right?
Okay, looking good.
Todd, you know what? I follow Instagram a little bit, and everything I see on there, I guess it's stuff that I click on, and it just keeps feeding me the same stuff. But there's a ton of material out there on estate planning right now and doing trusts right now, and Todd, what are all the resources available to somebody out there that wants to do a trust? I mean, who could they turn to? What resources do they have in putting a trust together?
That's a good question because the obvious answer is there's attorneys. You can hire an estate planning law firm. There's also attorneys that aren't estate planning attorneys that dabble in estate planning.
Seems like a lot of attorneys dabble in it. Yeah.
So then there are non-attorneys. There are what I refer to as document preparers, where they don't hold themselves out as someone that can give you legal advice, but they'll convince you that all you need is a boilerplate document, and they can prepare that document for you. Similar to online services, where you can, like a Legal Zoom, where you kind of order what document you want and it compiles it for you.
I've seen a lot of commercials, Todd, on TV about different financial institutions and financial companies, and I've gone to even some of these financial seminars, and it's interesting to me, they lead off with, and almost 90% of their seminar is on the benefits of doing a trust. What's going on there? Why am I seeing such a flurry of financial companies talking about trusts?
I think it's because they recognize that the questions people are asking right now are about estate planning, and they recognize that if they can provide answers to that, they can get people in the door.
Yeah.
And so they're trying to build their own business by leaning on questions that their clients are asking.
Yeah, and I think, I don't know if the public realizes yet, but you don't have to be a law firm, or strike that, you don't have to be a lawyer to own a law firm in Arizona. Talk to me about this recent change in Arizona law on that.
Yeah, so the change is that we have what we call our alternative business structures have been authorized by the law now to be created, where anybody can be, once they go through the application and vetting process, anybody can be a partner or an owner of a law firm that practices law, where before that was something that was regulated and restricted, where only lawyers licensed in Arizona could be the owners of law firms in Arizona.
Well, Todd, our website guys are sitting across these cameras looking at us, filming us here. They tell us that one of the most frequently searched question is, do I need a lawyer to do my trust? And for us, obviously it's a resounding yes, and that sounds self-serving. But I want to get into this video for just a minute, things that a lawyer can bring to the table that maybe a financial planner can't, or maybe the dialogue that they're not going to get on LegalZoom. But would you agree? I mean, would you ever think about putting together your own trust?
Right. I think I'm with you there. I think that specifically, and there are a lot of different things I could grab onto here, but I'll grab onto knowledge of the estate tax.
Yeah.
I mean, that's something that I think is necessary for someone to give a client advice about how to do a trust.
Yeah.
An underlying knowledge of the estate tax, I think, is essential. And if you're going through a document preparer, somebody that doesn't have that, I think that you won't even know what's not there in this boilerplate document that you've purchased. So that's why I agree with you. I think that it is essential to have an attorney that's trained in those.
Well, especially, I mean, you take a look at our law firm where, I've been practicing for over 40 years. I think you've got, 15, 16 years doing this. It's those life experiences that we bring to the table. In fact, in one of our probate videos, I think I made the comment, hire a grandpa, not a kid. And I think that also applies a little bit to estate planning, hire a grandpa, not a kid. Because I tell people, I don't practice estate planning, I've lived it. How do you know how to treat in-laws until you've had some in-laws? How do you know what your kids are going to do with money and wealth until you've seen them with money and wealth? And how do divorces impact an estate plan? And I don't know how many times when I'm doing an estate plan for somebody, I'll bring up a particular topic, like maybe inserting a power of appointment into a trust. And a lot of times the clients will ask me, well, what do other people do? Mm-hmm. And I think that's very critical. And I think when you hire one of these, we'll call them mass document preparers, and mass document preparers could be the estate lawyers that are younger, that really don't have any tax expertise, that they mass produce trusts. I often heard the term trust mill. And honestly, when I was a young lawyer, I was accused of being a trust mill. In those days we did a lot of seminars, and we cranked out a lot of trust, and that's kind of what young lawyers have to do to build their practice. They have to be very visible, and they have to crank out those hundreds. But as I've aged and I've had these life experiences with my kids, and grandkids have come on the scene, I find that my older clients that are my age and older, and I'm 68, and a lot of our clients are in that range between, I would say, 60 and 75. These life experiences that I've had, they're having. And it's interesting to me that I find that more clients are willing to spend more time talking about what I call the warm and fuzzy subjects of a trust. For example, here's a warm and fuzzy. I mean, when you die and you leave wealth to a child, does that, and we use the word child, but that person could be 50 or 60 years old, does that person have the right to leave that wealth to their spouse or to leave it to the grandkids? And there again, should I give my child the option of giving it to their spouse, or do I dictate that I always want it to stay in the bloodline? I mean, these are questions that you don't have time in a $3,000 or $4,000 trust to really crawl into that much detail.
You and I have debated in the past whether there's any meaning in the phrase, you don't know what you don't know.
Yeah.
And I think that it is applicable here when you're talking about an inexperienced attorney or a non-attorney that's just drafting documents. There's a confidence that they're providing you everything that you need, and it's not. And I think it's an honest confidence. It's just that it's an unearned confidence, and I think that's what you're talking about is all of the experience and all the variations of this that you've been through. You're able to give a lot deeper advice to somebody.
If people want that $4,000 trust or that $3,000 or $2,000, whatever the number is, and I see numbers all over Instagram about the pricing of a trust. To me, it's like a tract home versus a custom home, and it really is. I mean, I tell people all the time, email me $100 and I'll email you a trust. I mean, and it's a dang good trust, but you won't understand half of the provisions, and you won't understand what the options were, the other options were behind each provision, right? I mean, when we do these things, we're going into a lot of detail, and let's just take the consideration of who's going to be the trustee when you're gone. I think that question's searched all the time. Who's going to be that successor trustee? And then the other question is can your kids, or should your kids ever become a trustee? Or are we always going to have independent trustees? And if the kids are never going to become the trustee, what oversight do they have on the trustee? Do they have the power to remove and replace? Do they have to have a good cause to remove and replace? Or can they remove and replace for any reason? I mean, Todd, you can take any provision in a trust that looks like a common provision, and we could put 5 or 6 different spins on that provision.
And you picked an important one. I was going to say, with respect to the discussion about who to name as your successor trustee, you could easily spend an entire meeting with a client, spend an entire hour and a half where that's the only issue you discuss.
When clients and clients are willing to pay for that, that is a huge critical issue, this issue of trustee. And I remember when I was just a young lawyer, it's just like, oh, well, name the oldest kid and then the second oldest. We had this kind of patriarchal order type thing.
And you learn over time, at least I have, that the way things, the easier way to do things doesn't always mean it's the better way to do things. Yeah. And I'm like you. I think early in my career, I kind of went with whatever's easiest and that patriarchal order or whatever. But I think that what I've seen is that people respond to independent referee, somebody that's a professional that knows how to do this, jumping in as a successor trustee. And so it's become more and more common to discuss that. How about a professional fiduciary?
I look at it this way, Todd, and I'll, I think the old adage, you get what you pay for, and on Instagram it told me never use that term, you get what you pay for. Use the better term. I'm sure, Mr. Smith, you can recognize the value in what I bring to the table, right? I'm sure you can recognize that. 40 years of experience. What's the value of that? And, another thing that we can talk about here for a minute, we've talked about, the kids, but just what about your spouse? I mean, you die first, your spouse lives, the spouse remarries, the new husband or new wife, they have kids of their own. How do you blend in stepchildren? Where do they come in? What about adopted kids? Where do they come into this picture? What if they divorce? You know that.
Right, and whenever you're talking about inheritance going to any individual, whether you're talking about a spouse or a child or whoever, whenever a client says anything that you could describe as keeping a string on the control of the assets, we're talking about a trust.
Yeah.
We're talking about a trust within the trust. And I think it does add a layer of complication that you need to have somebody that has that experience, somebody that's seen every way there is to do it, somebody that's seen on the other end of this, how it works out at the end, to give you advice on how to draft that.
Yeah, and Todd, you know as well as I do, we take care of the high end and we take care of mainstream, America, right? We have both ends of the spectrum. But I would even argue that on our mainstream, our cookie cutter is 10 times better than the cookie cutter of that young lawyer out there doing seminars. Because we've built into our cookie cutter more of these options that are thought about for 50 million times with other clients. We build them into our cookie cutter.
And we recognize from experience, we recognize that not every situation needs to be super complicated.
Right.
Sometimes after talking to you and giving you advice, at the end of the day, what we present to you is fairly boilerplate.
Yeah.
And that's a good thing. Sometimes simpler is better. And it's recognizing when it works where you can get value.
Well, just so the audience knows this, and I'm going to throw out some numbers here, because I really think how much you pay for a trust really is based upon your net worth, right? And obviously, the more net worth that you have, the more time and energy should be spent on crawling into more and more detail and more options with respect to the kids and the spouse. And I'm just going to put it out there. I think generally speaking, in my mind, a really good estate plan, and and I'm going to put it in there let's take the client that's between the $1 million and $5 million, right? I mean, you could argue clients below $1 million may not even need a trust, and that there again, these younger attorneys are going to say, avoid probate and all this, and they're going to be putting these guys in a trust. Maybe not. The $1 million to $5 million, though, clearly these people need a trust, and I think a good range of fees there, Todd, is between probably $4,000 and $6,000.
I totally agree.
I kind of see on the low end a lot of stuff on Instagram. I'm seeing a lot of this $4,000 trust, and that seems to be the number that's thrown out from a lawyer's doing a trust. And I think, there again, a $4,000 trust, we can do a very good job. Now, a $6,000 trust, we're going to spend more time crawling into more detail of more of those provisions, right?
That's exactly right.
Now, if you're in that next, let's say that next step between $5 million and $10 million, then I think really, that trust, your estate plan should be somewhere now between maybe $5,000 and $10,000. There again, because now as you start getting closer to that $10 million, tax becomes more important. The estate tax becomes more important. Stepped up basis when you die, more important. The kids handling money becomes more important as a discussion. And should they have an independent? A lot more discussion. And so people think the wrong concept is, because I'm $10 million, you're just going to charge me that much more and it's the same work. No. At a $10 million estate, that estate plan, we're going to spend more time customizing more and more of those provisions. And I think that's a good range. Now, I think, Todd, the way we do it is the right way to do it. A new client comes in, will say, hire us initially to have 2 or 3 sessions with us. We'll call them design sessions. And in those sessions, maybe they'll pay us a fee of somewhere around $1,500 to maybe $2,000. And we're going to have just pure design sessions. It'd be almost like hiring an architect. And we're going to show them the different houses they can build and let them say, gosh, out of all these houses, this is the house I want. I want this customized. I want the kitchen bigger. I want the bedroom smaller. You get it. And then we'll quote them the fee to build the house. That way you're really kind of getting what you want, right? I mean, now we can have that. But talk to me about what you're seeing. How do clients react to that idea of pay us a fee for a design session or 2, and then we'll quote you a flat fee?
I think it's generally perfectly suited for what you're talking about when we're getting into the 10 million or more.
Yeah.
I think that's where it is. Some of these strategies that we're going to be throwing at them actually need to be discussed. There might be some reasons not to do it. There might be some reasons you got to worry about, and we want to make sure you understand that before you pull the trigger and do it. And so it's worth their time, I think, and this is what I'm hearing from them. It's worth their time just to explore it as an option.
Well, I think the attorney that quotes the $4,000 trust, go on our website, it's a $4,000 trust. Well, he has in his mind how much time he can afford to spend with you on the $4,000 trust. And usually what I'm seeing on these $4,000 trust is the attorney will spend 1 hour with the client up front. That's it. The next meeting is with the paralegal.
To sign some
we
documents.
Just hired a paralegal that came to us from what I would call a trust mill, and very familiar with their processes. I won't say where they're located because people would probably know which city I'm talking about. But that client that says, I've got the $4,000 trust, he's probably going to spend 1 hour with the client, period. The next meeting is with the paralegal to explain the provisions. And then the third meeting is for a paralegal and the attorney to sign the document. The attorney comes in for 10, 15 minutes, answers questions. Then so total attorney time, maybe an hour and 20 minutes. And then the paralegal has time in that. Now, that $4,000 trust, with that little of attorney time, those attorneys are making a handsome profit. They really are, right?
Right.
The difference is now, if you want to have more time with the attorney in the design, which I think is critical to get into all these details, then I think we're better off to talk about, hey, let's have a session or 2 first and let's do the design.
I agree.
Well, Todd, thanks. Is there anything else you want to add to this discussion? We answered the question being a lawyer. Yes. What's the difference between a $4,000 trust and say a $6,000 or $7,000 trust? It's just the amount of time that attorney is going to spend.
Yeah, I think this is what clients are asking for. Right now. This is what they need.
You know what? We don't want to nickel and dime a client, but we don't want the client to nickel and dime us either.
Right.
I mean, the guy that quotes the $4,000 trust and gets the client that's got the 50 million questions, that's not going to be a good fit. That client's going to be frustrated because the attorney's not going to want to spend that time.
I agree.
All right, well, thanks for your time today.